Start.
The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. Steve Shoemaker here from the Wishart Law Firm, and to my left, Tim Harbour. Both of us are associates at the firm, and we really appreciate everybody joining into today's Municipal Law webinar, which is the first in a number of webinar series for municipal issues that we intend on hosting. Today we are speaking about certain issues that may affect municipalities in the Funeral, Burial, Cremation Services Act, which we're going to be referring to today as the FBCSA, and what issues and highlights and risks may exist in that act that are relevant to municipalities. Again, thank you for joining us. I'm going to pass it off to Tim to continue, and we look forward to questions and answers at the end of the presentation. Thank you.
Yeah, thanks, Steve, and thanks everyone for joining. One of the things that we wanted to mention as well is we really want to hear from you as well. If there are other topics in the future that you'd like to have us do a webinar on, we invite you. Our contact information is going to be provided as the last slide. But we'd very much like you to get in touch with us. We're constantly looking for new ideas, and so we value your input for sure. If you can just hit the next. Yeah, so I wanted to just run us through take us through an outline of today's presentation, and that really what we're going to be talking about. The funeral and burial, the FBCSA, which is a term I still I'm getting used to saying, is really a huge act, and with the limited time we have, unfortunately we aren't able to give a complete run through the act. So we wanted to do is highlight some of the things that Steve and I felt would be most useful from a practical perspective for municipalities to know about. And so with that in mind, the first thing we're going to talk about is just really the highlights of the Act itself. We're going to talk then about some of this new Ontario Bereavement Authority, which became effective April 1st, 2016, just really touching on that at a high level just to give you a flavor of what the responsibilities and structure of the BAO is. We're going to talk about some selected issues that Steve and I have actually dealt with in our practice relating to cemetery property maintenance. So hopefully there'll be some practical takeaways there. Similarly, we're going to move on to talking about personal information in a cemetery context. Really, we're going to talk about Municipal Freedom of Information and Protection of Privacy Act and sort of how that interplays with the FBCSA. We're going to talk about public access to information, and we're going to close out with hopefully some time for question and answers. And I believe there's a way for you to enter your questions electronically, and we'll do our best to pick those up at the end. So Steve, you can flip the next slide for me. So under the highlights section of the FBCSA, we want to talk about 5 things. The first of which is the contract is certain contract requirements that the FBCSA imposes. And I'm just I've printed out a copy of the Act, and so I'm going to be referring to it as we go forward today. So one of the things that with contract requirements, obviously it has to be in writing, signed by both parties. It has to comply with certain of the regulations. In particular, Ontario Regulation 3011, for example, sets out requirements that the contract be legibly printed in 10 font or greater. Contract has to set out the purchaser's rights of cancellation under the Act, which we're going to talk about. The contract sets out all the supplies and services to be provided and the price to be charged for them. If it doesn't, it won't be enforceable. Similarly, there's delivery requirements that are prescribed by the regulation. In addition, there are some specific contracts that I just wanted to draw your attention to that are exempt from the requirements. And those requirements I was just referring to are under Section 40 sub 1 of the Act. So if you look at Section 122, for example, and there are specific contracts thereunder that are exempt from those requirements we just talked about. Probably the most interesting of which is contracts for which the total purchase price is $250 or less. And with those, it's interesting because the Act specifically contemplates the idea that some people may want to circumvent those requirements by just having separate contracts so that the value of each is limited to less than $250. And so 122 subsection 2 basically says that it prohibits entering into multiple contracts, basically for the purposes of frustrating the requirements of Section 40. You're getting around them. So it's contemplated that. So just something to be aware of.
And I think Tim, we're looking for this to be sort of a free-flowing discussion. So I think one of the important aspects to note about the new FBSCA is the fact that it is very concerned with greater consumer protection, because I believe that the reasoning behind the combination and combining of the funeral, burial, and cremation services markets into a single act was for primarily the protection of consumers who were being negatively affected and entering into punitive contracts against themselves in respect of such a sensitive issue.
Exactly, and that's really what we're really seeing with the contract requirements is exactly what Steve was talking about. The FBCSA really is, in many ways, it's consumer protection legislation, and we're gonna see that when we talk about the right to cancel contracts and some of the resale provisions as well that were absent from the previous act. So actually, I'm going to ask Steve to just flip to the next slide for me. Actually, you know what, Steve? If you can go back, my apologies. We're going to talk about the BAU. Of course, afterwards, I just wanted to run through the right to cancel contracts and some of the other highlights.
Yes, including we're going to speak to as well the resale of unused interment and scattering rights, which we may simply just refer to as internment rights to be short and concise. Payment to care and maintenance fund in lieu of property taxes, where cemeteries or religious groups are the owners / cemetery operators, where taxation wouldn't typically take place, and the bylaw approval process. So I'll leave that to you, Tim, on the next issue, which is right to cancel contracts.
Yeah, and so what we're seeing, if you can go back, Steve, we'll just stay on this this slide for the time being. The 30-day, basically what the right to cancel contracts is all about is it gives consumers a 30-day cooling off period within 30 days of making a purchase under the Act. A consumer may cancel that contract and receive a full refund on funeral services and supplies that have not yet been provided. And so within that 30-day cooling off period, the operator, and the operator, as we know, can be a municipality, may not charge any administrative fees or make any further deductions from any amounts already paid, which are to be refunded in full. And so once that 30-day cooling off period expires, a consumer can still cancel the contract and receive a refund for unused funeral supplies and services, but there can be a cancellation fee. And the amount of that cancellation fee is limited to 10% up to a maximum of $350.
Good. Which is consistent again with the consumer protection model of the Act.
Yes, yeah, and within that 30-day period, if the supplies or services have been used, there's of course no obligation to provide a refund if they've been used in either on those specific items or if the items in total have been used. So now we'll talk about just briefly the resale rights. Basically, the Act under Section 47 gives interment and scattering rights holders, as the case may be, the right to resell those rights to third parties. The caveat being is that municipal or cemetery bylaws can prohibit such resale, and we're going to talk about what the effect of prohibiting that is. Before we do, I just want to mention there's a prohibition on speculation. And basically that's under 47 sub 3 of the Act. Basically, prevents a person from buying interment rights for the sole purpose of the sole or primary purpose of reselling them to get a profit. And so it contemplates the idea that there might be some speculation in the market. And if your bylaws do prohibit the resale to third parties, the rights holder basically can cancel the contract, but also they can actually give written notice and require the operator, or as the case would be the municipality, to repurchase those interment or scattering rights. And so when we talk about the repurchase option, if there's a cancellation or basically the operator is required to pay the greater of all monies received under the contract or market value. And market value is determined as the price which is set out on the cemetery price list, or if there's no price set out, it's market value, and there's some specific enumerated ways that can be calculated under Section 142 sub 1 of the Ontario Regulation 3011. So the payment, I'm just going to move on actually to the payment to the care and maintenance fund. So basically, land that's being used as a cemetery is going to be, there's a number of ways that property can be exempt from taxation. I'm thinking in particular under Section 3 sub 1 of the Assessment Act, where land is being used, as I mentioned, as a cemetery. Basically, what happens is the cemetery operator, if your property is exempt, the amount that you would normally be paying in tax is deemed to be payable to the care and maintenance fund under the Act. And so that's just something that I wanted to make everybody aware of, that you are to pay the amount that would otherwise be payable as taxes in respect of the cemetery property into the care and maintenance fund.
Right, and I think that, Tim, just to interject, is consistent with the consumer protection approach to this act, in that it's a good governance and open and transparent manner in which they're requiring that the funds be available so that these cemeteries can operate in an appropriate fashion. The investments made by interment rights holders can be adequately satisfied, and the contracts can be adhered to. So again, this is the angle that we're seeing with the FB CSA, is this consumer protection / open and transparent manner in which the parties are being required to conduct themselves.
Yes, yeah, exactly. And going along with that transparency actually is there's actually some very specific requirements for bylaw approval, which I'm going to talk about briefly, that I think really go to what Steve's point is that, you know, the idea of the Act is really to create an openness surrounding the operation of cemeteries. So, really what you have to do with bylaws, and that comes under Section 151 sub 1 of the FBCSA. We've got a situation where you have to actually publish notice of the filing of the bylaw. Basically, you have to publish it in a newspaper, and I'm looking at section. And I'm just looking at my copy of the Act. It's Section 151, subsection 3. It says the cemetery operator shall ensure that notice of the filing of the bylaw or bylaw amendment is published once in a newspaper with general circulation in the locality in which the cemetery is located, so a local paper. It's got to be conspicuously posted at the entrance, on a sign at the entrance to the cemetery. It's got to be delivered to each supplier of markers who has delivered a marker to the cemetery in the previous year. That notice generally shall state the location at which interested persons may review the bylaw, indicate that the bylaw or bylaw amendment, as the case may be, is not effective until the registrar approves it, and provide contact information for the registrar and the cemetery operator for purposes of the public making submissions on the bylaw. So again, sort of what Steve's saying is this Act really is about accountability and transparency, and this idea of the bylaws being sort of conspicuously posted for public inspection just goes right back to that point.
And I think, sorry to interrupt you there,
Steve,
Tim, just to interject, I think that's important to note as well, the publication of the bylaw being in a conspicuous spot prior to entrance and entrance driveways to the cemeteries, which will go hand in hand with an issue that we're going to be discussing later in the presentation, in the making certain information available at the entrance of the cemeteries as well. For example, where certain individuals are buried, and other types of personal information that under the FBSCA, not only are the cemetery operators, which can be a municipality of course, required to maintain, but that they are also required to make available to the public upon demand.
Yes, exactly.
Which we'll get to later on in the presentation.
Definitely, and just to close off the discussion of the bylaws, and to bring things back to what we talked about earlier, we feel obviously that the bylaws should address things like the rights, entitlements, and restrictions with respect to interment and scattering rights, installation of monuments and markers. That's an issue that actually has come up relatively frequently for Stephen and I. This idea of what types of markers can be placed in a cemetery, and the bylaws can speak to that, and actually, we recommend that they do. Obviously, as well, if your bylaws can indicate the allowance or prohibition of reselling of rights, that should be a prime consideration. There's a few other minor requirements, things like the bylaw can't prohibit the rights holder from making arrangements by telephone or otherwise, and the bylaw may still require consent or confirmation of authority to act, including signatures prior to providing a supply or service. So that's basically it for what I wanted to talk about bylaws, and now we can go to the next slide. So as of April 1st, 2016, the BAO is basically taking on an administrative role with certain provisions of the Act relating to funeral transfer services, which were previously the responsibility of the Board of Funeral Services. The BAO will, and this is just sort of high level, but the BAO is going to provide basically a single point of contact, and I think that's really, the takeaway from this slide is that the BAO, the idea of this sort of consolidation of the administrative responsibility in the BAO is really to provide more efficiency in delivery and enforcement, a single point of contact, and really a single inspector, an inspection role. If you look at the way it's structured right now, as I say, it's just starting really, but right now it has 16 staff. It has a registrar, and it's organized into 2 units: education, licensing, and outreach, as well as compliance. And so we're going to be keeping an eye on some of the developments that are happening with the Bereavement Authority of Ontario, and may provide an update or a supplementary workshop as we know a bit more about their role.
And I think it's a good further indication that even though this act was passed and proclaimed into force in 2012, that there are current events occurring as the act continues to be developed and regulated and administered in the best manner possible for consumers in Ontario, and for cemetery operators, which of course include municipalities in numerous cases. And we're seeing here that only recently in 2016, here about a month ago, a further authority has been put in place to administer certain aspects of the Act. And so as we move forward, we'll be able to continue helping provide information, respective changes and occurrences with this Act. One of the integral issues that I'd like to speak about today is an issue that seems to be arising quite often. I've seen it from a number of municipal clients recently, is individuals who would, or groups, sometimes religious groups, sometimes other types of volunteer groups, school groups that would like to help maintain the cemetery lands. And so if it's a situation where Today's aspects of the webinar are geared towards cemetery operators being municipalities. The municipality can have quite a few risks and potential liabilities arise if it's not careful in following the exact language of its bylaw. Pursuant to the Act, the bylaw must be, the cemetery must be operated in accordance with the bylaw, and that's section 150 of the Act. Depending on what language is included in the bylaws of the municipality, there may be restrictions on the types of third parties that can provide maintenance and cleanup and actually touching and affecting the gravestone, tombstones, and plots themselves. So it's very integral, of course, that the municipality know exactly who's permitted to access these gravestone markers and the plots themselves. Now, the question isn't whether the individuals who have purchased these rights or the rights holders themselves. Sometimes those two, the purchaser and the rights holders, are one and the same. The question isn't whether those individuals are allowed to touch their own gravestones and affect their own gravestones, but the question is as to which third parties are permitted to lift gravestones or affect the plot in any way. And where an unauthorized individual affects a gravestone or a plot in any manner, they can be found liable pursuant to the Act, which is under section 103 of the Act. And so, for example, if a religious group, despite their best intentions, is looking to clean up old gravestones or help cut the grass or help sweep walkways, there could be some issues depending on the scope and extent of the work that they would like to help provide on a volunteer basis. And that also raises the specter of concern of potential liability, whether a volunteer individual were, for example, to trip and fall, the cemetery owner, and in this case the municipality, would be considered an occupier under the Occupiers Liability Act. Presumably the volunteer group would have been invited with the authorization of the municipality to attend on those lands, so they themselves would be invitees as well. And so there are these issues that do arise and these risks that need to be dealt with and considered prior to approving any access to the cemetery lands by anybody that isn't specifically covered in the bylaw language.
And just on that point, Steve, that's I like what you said about these people being invitees, even if they haven't been specifically authorized, but their sort of presence and the work that they're doing is not challenged. It can be seen that it's acquiesced to by the municipality, and so there could be liability similarly arising just by acquiescence. And also, what about the situation, Steve, that I'm just thinking here, where an individual is having there's one of these groups that's well intentioned, actually damages the marker or other ornamentation on an interment rights holder's site.
There is liability within the Act provided for in section 103, I believe, and it provides that any damage which is required to be rectified to bring the site, the gravestone, or the plot back to the condition it was in prior to the damage occurring, that an individual can be found to be would be found to be liable in accordance with the Act for the damages that have occurred. So it's not only damages that can occur to the individual themselves, correct, that they may simply be acquiesced in their attendance on the property, not necessarily authorized by the municipality or approved as invitees, but there would still be liability for their injuries and likely no contributory liability on those individuals. So the full liability could potentially lie with the municipality. And there could be even further liability as well, because depending on the situations that do arise, there was an example I had recently of a religious group wanted to attempt to determine whether they could get information, personal information from the town, from the municipality, to update unmarked gravestones. Now, it seems like a relatively innocuous request that one would want to accept and have the volunteer group look into. But of course it raises the specter of the risks in disclosing personal information. Where a municipality is the owner and cemetery operator, the MFIPA, Municipal Freedom of Information and Protection of Privacy Act, applies to the disclosure of personal information. Now the Act, the FBSCA Act, does require cemetery operators, and in this case we're talking about municipalities, to maintain certain information in a publicly available register. And that information, which is required to be disclosed to the public upon request, would otherwise be personal information that could not be disclosed by the municipality, but because it's part of a public register, it falls under an exemption in MFIPA, the Municipal Freedom of Information and Protection of Privacy Act, that being Section 27 of the MFIPA Act. So it's important for municipalities to be aware of what their disclosure obligations are under the the FBSCA Act, as well as how that disclosure is statutorily provided for under MFIPA. The further issue in respect to my example, for example, becomes whether the municipality could disclose information to someone requesting information about unmarked graves. MFIPA allows information to be disclosed where the deceased individual has been deceased for at least 30 years. And so typically in an unmarked grave situation, we'd be talking far longer than 30 years, and the municipality could disclose information in respect of the unmarked grave that it may have in its records without being in violation of MFIPA. Sections, back to the funeral, the FBSCA Act, Section 110 of the Regulation 30/11, which is the general regulation of the FBSCA Act.
I want to interject for a second, Steve. I apologize for that. I think if we move to the, actually I think we may be able to move at this point to the last slide, and,
Okay.
and maybe you might like to take.
Yeah, sorry about that. I hadn't updated the slides. Thanks, Tim. The slides here provide some of the information that is required to be publicly disclosed if requested pursuant to the FBSCA Act. And these slides are going to be made available on request to anyone listening to today's webinar. And again, that was Section 110, Sub 1 of the general regulation, the type of information that must be maintained and must be made publicly available if requested. Okay, and there's, as we had mentioned, there's the further question as to whether the register information and the location of plots and individuals who have been buried or scattered can be disclosed either in an online form or oftentimes, as I've seen before, at the entrance of the cemetery lands. And I'm going to allow Tim to speak to that, and look forward to hearing what he has to say about that.
Yeah, well, actually, that is an interesting question, and we've seen a number of municipalities actually are beginning to post the register online, and there's absolutely nothing wrong with doing so. There's nothing in the Act that prohibits a municipality from posting the register online, and in fact, I would say that it's actually part of it goes in keeping with the spirit of the Act and making information as readily available as possible, and so. One of the things to bear in mind with that, though, is that even if the register is available online, it's still a record for the purposes of Section 96 of Ontario Regulation 30/11, and so it's required to be. If somebody wants a hard copy of that, one has to be readily available to be printed for them, and that's under Section 97 Sub 2 of the Act. So that's just something to bear in mind. I think having the register online is a great idea. It goes with the spirit of the Act, but just make sure you have the ability to print it if somebody either doesn't have access to the internet or just wants to come in and see it in hard copy.
That's all for the slides that we have today. Again, we thank everybody for attending. The response has been very appreciated, and we're going to take some questions and answers here. We've gone the allotted time on our presentation, but we'd still like to hear from individuals in attendance today and listening to the webinar as to what their concerns and questions and perhaps issues they'd like to have us help them with on the FBSCA. Any questions that we don't get to, because we'll take a few minutes here, we will certainly be more than willing to review. And if you'd like to reach out to us, our contact information is here on the screen at this time. And we'd be happy to answer any and all questions that we won't necessarily get to on today's webinar.
Exactly. I mean, we can follow up for certain questions. We can certainly follow up by email or a phone call. So yeah, look forward to responding.
I'm not seeing. I see some questions here. An individual asked to see if there would be any more information about the BAO, which because of the recency of the BAO, we certainly can put on a subsequent webinar to the BAO and inform everybody and notify everybody of that webinar. And we'll certainly put that right at the top of our list, given that it's recently come out. Perhaps we'll wait to see if there's some happenings with and information and news that comes out from that BAO being in place at this point.
And actually, on that point, I just wanted to remind everyone that today's webinar, the intention is that it will be posted and hosted on our website, www.wishartlaw.com. And what Steve and I will endeavor to do as well on the page that the presentation is hosted, as new developments become available with respect to the BAO, we can post hyperlinks and other information, so it'll be all right there, all in one spot for you.
I see another question here. You recommend that the public register be posted online. What about the location of plots and the scattered remains? And the location of plots and the internment and scattered rights is information that's subsequent to or subject to Section 110 of the General Regulation, is information that is required to be maintained and available to the public. So that information could as well be posted, provided publicly to individuals who make the request, or posted on an online database. We will make the PowerPoint presentation available, as Tim had indicated, on the website, on our firm website. There's a question here, Tim, perhaps is best directed to you.
Okay.
You mentioned the resale and cancellation of plots. What about the transfer of plots?
The transfer of plots. So what I take to mean by that is the transfer by and I'm just speculating, but the transfer might be affected just by maybe an estate being passed by an estate, and so you'd certainly want to have documentation evidencing that transfer and making the municipality aware of that if you're a rights holder. Similarly, if you transfer your rights for nominal value, I suggest similarly just make sure you have evidence of that written contract, even if it's simply that you're doing it as a favor for a friend or a neighbor. I imagine most likely though it would come up in conveyances through wills, and I think in that case the onus would be on the transferee to prove that they had a legitimate right to that internment or scattering right.
And I think it goes as well, Tim, having listened to and spoke with you about this leading up to the webinar, goes hand in hand as well with, depending on what the exact question is there, the transfer to third parties potentially, which, depending on the language of the bylaw in place, third-party transfers may actually be prohibited, in which case the transfer could, depending on the question being asked here, I'm talking about outside of the wills and transfer within an estate, but to to arm's length third parties, some of those transfers can be restricted, and so the sale of a right being held by a rights holder could only be back to the cemetery operator if prohibited, which goes back to the slide that we had earlier in the presentation. I'm going to take one more here, a question, and again I thank everybody for the fantastic questions provided. Can you clarify the municipal payment to care and maintenance fund in lieu of property taxes? Is that mandatory for all municipalities to contribute? And I think you had some information on that, Tim. And we could certainly provide a greater opinion and provide greater advice in respect of a question like that, which is a bit more complex than we'll be able to answer here today, but we do have some general information on that.
Yeah, and I'm just actually searching, as you can see, for my my notes with respect to that payment. In essence, and I'll read you the section. It's section 92 sub 1, and I'll just briefly read it for everybody. Who I'm sure it's not necessarily in front of you at the moment, but. If a cemetery is exempt from property taxes imposed under the Municipal Act 2001, the City of Toronto Act 2006, or the Provincial Land Tax Act 2006 by reason of paragraph 2.1 or subparagraph 2.22 of subsection 3.1 of the Assessment Act in relation to a crematorium, and if the registrar under the Cemeteries Act revised or the registrar consented after January 1st, 2002, the establishment of a crematorium, or the operator of the cemetery, or the operator of a cemetery shall make payment into the care and maintenance fund, as the case may be. And I'm just looking for the second page of that, or maybe Steve can help me out by putting that up on the screen for me. And we'll I know we're sharing the screen with everyone here today, so you'll be able to see that as well. And I don't have my glasses on, so I may leave it to Steve to take you through that. But
yeah, the operator of the cemetery shall, so they are required to make the payment into the care and maintenance fund, or for the account of the cemetery, as the case may be. And so, essentially, as a brief response to that question, the point is that because, depending on the owner and of the lands, and in this case we're talking about municipalities today, would typically be exempt from the payment of taxation on those lands. But rather than being exempt and not paying taxes whatsoever, the taxes that would be otherwise owing on the assessed value of those lands would be paid into the care and maintenance fund.
Yes, exactly. And there's under that section 92, there are some detailed provisions surrounding that payment. But as Steve said, the main takeaway is it's basically saying, well, you know, if you'd otherwise be required to pay certain taxes owing on this land, but it's exempt for under the acts that we talked about under section 92, then the idea is to take that money that would otherwise be owing and put it back into the care and maintenance fund for the cemetery. That's in a nutshell the takeaway. And if there are more specific questions on this, it's probably easier to direct them to Stephen and I, and we can give a more fulsome response.
And our emails are up on the screen, and we'd like to say thank you once again to everybody who's joined. I saw that there was upwards of almost 40 attendees on today's webinar, and we are going to be putting these webinars on fairly periodically, and we look forward to having everybody attend again. Thank you very much.
Thanks, everyone.